All right, we'll give it a few more, about 30 more seconds before we kick off. All righty. Well, thank you everyone for joining us today for the Exit Advisor Small Business Town Hall series. As you know, we've been doing this for several months now. We've had some great dynamic topics for you, including today. We're featuring Aaron Ball. Aaron's a perfect example of the collaboration that Exit Advisors takes with its business partners. Aaron's a very successful attorney here in Houston, and we like to work with him pretty closely. So he's going to be going into a very unique topic, Phoenix or Fire Trap, and it's going to be around the dynamics of acquiring a distressed business. And I'm going to let Gary introduce him in just a moment, but before we do, I'll give you the quick 30,000-foot overview. Exit Advisors is a Houston-based M&A advisory firm, and we focus on the lower middle market. That's the typical $5 to $50 million business in terms of total enterprise value. As you know, as I just mentioned, we like to take a very collaborative approach with other business partners so that we can create the best deal team for you as a client. It's talent, whether it's the legal side, the M&A side, which is us, your CPA, or guys like Jason Knight, who we featured in the past doing operating systems. We really take an education-based approach so that we can, work with these entrepreneurs and business owners months, maybe even years in advance to really prep them for an exit. And then we bring in the heavy hitters like Aaron to help get us through the really rocky parts. So without further ado, I'm going to pass it over to Gary, who's going to give you a little intro to Aaron. Gary, you there?
Yeah, I'm here. I was muted. I guess it just said to unmute. So sorry about that. My name's Gary Cooper. I'm a member of Exit Advisors and partner of Cooper CPA Group. And I get the luxury of introducing Aaron today. Aaron Ball is going to put on a great presentation for you today. Aaron has great experience, both working inside large law firms, having his own practice, being in-house counsel for companies, very entrepreneurial. Aaron and I have worked on transactions together in numerous cases in which he took the lead, even in a situation where a company as large as Sylvania, Aaron was the one that took the lead with all the legal points to really make a transaction complete itself. He also helps me with a lot of my small business clients with corporate law and a sundry of other things. So I'd like to introduce Aaron. Aaron, if you want to expand a little bit on what I was able to tell our audience, go for it, man. But I'm really looking forward to this presentation.
Thanks, Gary. Can everybody hear me? Am I coming through?
Yeah, we hear you loud and clear.
Super. All right. Thanks, Andrew. Thanks, Gary. I really appreciate Exit Advisors having me here today. I'm really excited about this topic. It's a huge topic, and it's a lot for us to cover in 30 to 40 minutes, and we have a mixed group, so I'm going to try and cover some of the fundamentals as well as some of the more nuanced sides of this. Brief overview. There we go. What I'm covering today, I'm going to talk about why buy a distressed company, what is a distressed company, some of the general considerations when buying a distressed company, like what type of sale methodology do you use, the types of distressed sellers, because that can impact how you approach a deal, such as with due diligence, how you tee up the transaction structure, how you set the framework up to help you and conduct the due diligence to help you deal with some of the primary deal risks associated with buying a distressed company, such as fraudulent conveyance, successor liability, and fraudulent inducement. So underlying some of the stuff I'm talking about today, I've got certain assumptions. One, we're going to be imagining that our target company is privately held. It's a closely held company, not too many shareholders, and it's in the lower middle market. Now, I know there were some questions that came in about what the lower middle market is. You get varying definitions, but for our purposes today, we're defining lower middle market as between $5 and $100 million in annual revenue. Someone also asked the question prior to the presentation about how many companies that might be. The most recent estimates that I got were from about a year or a year and a half old. Peg that at about 355,000 companies in the US. Of course, that's a broad range, and I suspect the numbers are higher post-COVID. That means that there are a lot more of these companies than any other market segment, and they tend to be highly fragmented in highly profitable industries, which means that they're often really attractive targets for private equity roll-ups and consolidation by larger companies. Why buy a distressed company? Well, the notion is pretty simple. You can buy a distressed company at a lower valuation, lower purchase price, and increase its profitability. It can also be a great low-cost way of entering a market, or if you're in an existing business, expanding into either a new or related market or a new geographic area. The problem with distressed companies is that they present a great deal of risk and potential for post-closing liability with these three areas, which I mentioned earlier: fraudulent transfers, successor liability, and fraudulent inducement. And how you position yourself and how you prioritize certain aspects of your analysis and how you conduct due diligence will be based on certain factors about the seller, their type of distress, and what industry they're in. So what is a distressed seller? Well, there's a range. There's a classic definition, and most people think of insolvency as the arbiter of being a distressed company. I think of it as a broader spectrum than that. You have the classic definition of a distressed company as one that's insolvent on a balance sheet basis, meaning its debts simply exceed its assets. And then there's the cash flow definition, which says that a company is unable to pay its debts as they become due. But there's an even broader range than that, especially for attorneys who are dealing with board of directors, fiduciary duty issues, and creditors. And that there are companies within the zone of insolvency, those experiencing temporary insolvency on a different basis, as well as companies who are not necessarily distressed, but the owners or the owner and manager is distressed. That's not a distressed company per se, but a distressed owner that puts the company within the distressed category, and you approach them in a very similar fashion as the other companies. So on the left-hand side, you have the internal distressed company where the management or perhaps the owners are in dispute. It's causing problems within the company. And typically that's very often linked to external, temporary, or cyclical distress, because that dispute bleeds over into how the company functions, and it can start to negatively impact operations. When I talk about the zone of insolvency, we're talking about a company that probably has some cash flow distress, but is circling the drain on balance sheet insolvency, but hasn't reached it yet. And the reason why that's important for lawyers is because you start to have shifting duties between managers and directors of the company, between the shareholders or the owners and the creditors. So that's an important distinction. And then the classic insolvent company whose debts are simply exceed their assets. So once we know what type of company we have, what are the various sale methods available to us? And there are generally three. It's a bankruptcy sale, which is called a 363 sale, a private or direct sale, or what's called an ABC sale, which is an assignment for the benefit of creditors. And I'm going to try and, sorry guys, I'm going to try and move the video screen around so I can read my slides better. So as you can see from the arrows on the screen, you've got these 3 different types of sales, and I've placed them over the types of distressed businesses that they typically apply to. In general, bankruptcy is something that companies on the higher end of the spectrum between that $5 and $100 million tend to employ, whereas the smaller a company gets, the more likely it is to use either a private direct sale or an ABC sale. So between these 3 types, bankruptcy is very attractive to buyers. But today we're going to be talking about private or direct sales predominantly. And why is that? Well, the bankruptcy process is a legal process. It's public, it's competitive, and it can be costly to participate in that sale process, none of which guarantees a purchase. The advantage is the big upside to going into a bankruptcy sale as a purchaser is that it affords you a lot of protections against these, especially these 3 highest risk areas that I mentioned in the earlier slide. But typically buyers perceive the process as too slow and too expensive. And so most of the people on the spectrum, from the eternal distress all the way up to the zone of insolvency, and even some insolvent companies prefer to go with private direct sales. The ABC sale, it's basically a state or common law alternative to bankruptcy. And it involves the distressed company selling or assigning all of its assets into a trust. And the trustee of that trust selling off, with the approval of the creditors, selling off those assets to satisfy the debt, leaving whatever assets remain for liquidation. Now, that can be advantageous to a buyer who simply wants to buy equipment, but typically buyers want more than just the equipment that's left over at the end of the process. And an ABC sale necessarily involves the termination of the existing business that's being sold pursuant to that trustee asset sale. And as a result, it was more popular 40 or 50 years ago. It's become less popular over time, primarily because a lot of the stigma associated with bankruptcy has been similarly diminished over the same time period. So we've got these 2 methods of selling lower middle market businesses, and I put up on the screen some of the advantages and disadvantages of each. And you'll note that I call, most people know that, generically speaking, that when you buy a company, if you buy the stock or the equity, you're succeeding to the liabilities of the target company. If you buy the assets, generally speaking, people think that they're not acceding to any of the liabilities of the selling company. But usually very few of the sales that take place in a distressed context for most lower middle market companies are pure asset sales. In fact, most of the pure asset sales take place in the bankruptcy context, where one manufacturer, for example, will know that his competitor is going into bankruptcy, and he'll go and buy some machinery out of that bankruptcy asset sale, the 363 sale, to put in his own shop. But most of the buyers that want to buy a business and not just the assets will go into a hybrid sale where they're assuming some of the contract liabilities. Maybe they're acquiring the name, they're acquiring some intellectual property and branding that goes along with the distressed company, as well as just the plain assets. And that increases the risk. But the advantages are that it's a private process. There's no formal legal process like you have in the bankruptcy context. There isn't a requirement for creditor approval like you have on the bankruptcy side, but all of these other risks add up to make it a more challenging way in many respects to acquire a business than in the bankruptcy context. I'm going to talk about now about what I call the 4 different generic types of distressed sellers. And categorizing your seller is important to setting priorities for due diligence and looking at what parts of the transaction structure you're going to have to emphasize as part of your deal. Typically, sellers in the distressed arena are under a lot of pressure. They've got to stop some bleeding. And the most distressed form of seller owner is what I call the panic burnout seller. He knows his business is in trouble. He's willing to negotiate on price, maybe even on an earnout basis. He's personally burned out, has financial troubles, maybe personal problems. And what you find in the business is what I generally call a cultural malaise. Because the owner is stressed out, there's been a lot of turnover in the business. And the people who remain are apathetic. Maybe new hires that are coming in are of a lower quality than the previous hires because they're willing to accept perhaps lower wages so that they can cut costs. And this seller simply wants to stop the bleeding and stop the pain as quickly as possible. The danger with this type of seller is that there is a high incentive to commit fraud by either inflating assets, mischaracterizing their condition, ignoring pending litigation and other claims, things of that sort, which raise the possibility for post-closing liability. Second type of seller is what I call the denial seller. He knows the business is in trouble or has hit its limit, but he blames it on external factors. 2019, that was just a bad year. Not common for our industry. 2020, we blame that on COVID. 2018 is the year you need to look at for pricing based on, the multiple for this deal. He's willing to negotiate on price, but he's really focused on potential. He points back to 2018 and says, that really represents what our business is about. 2018, that was our year. That's what you should really base the value on. Plus, if you extrapolate 2018 out, you'll see that our business has tons of potential, and therefore this justifies a higher price. Often these guys feel emotionally attached to their business. And, just like somebody who's selling the home poured a lot of money into that deck in their backyard, and they think that they should get their money back on it, they're often disappointed. The clean seller. The clean seller is misleading because the clean seller is nothing more than the panic burnout seller in a cape. They're a really good liar, and they're really good at disguising all kinds of liabilities about their business. The answer typically with the clean seller in this context is to run, although there are some occasions where the opportunity will arise to exploit the clean seller for the buyer's benefit. Then there's the actually clean seller who's invested time preparing for a sale. Their business is relatively clean and they're prepared for due diligence. Maybe they've hired a good advisor. They have a realistic view of valuation and terms for valuation, but they're extremely rare. And you'll notice that on the denial seller, I placed a first place ribbon because that in general is going to be the type of seller owner that you're going to be dealing with in most of these in most, at least the bottom half of the lower middle market distressed companies. Some other items that might add to the complexity, excuse me, in a distressed business acquisition could be several of these factors. You've got extended family ownership that is involved in the decision making. The sale of the business could be one of those exceptions in, for example, their company agreement, where it says if you sell all the assets of the business, you have to have supermajority approval. Suddenly, Aunt Becky can have a vote that affects your ability to sell the company. The presence of secured lenders. Sometimes when you're under the right circumstances, the presence of secured lenders can facilitate a quick sale through a friendly foreclosure or a friendly sale. However, they very often do not afford the buyer the same types of protections against post-closing liability that a direct negotiation would produce. Employee ownership, like the extended family, can add complexity, especially when you have supermajority requirements in the target company's shareholder agreement or operating agreement that say that you have to get a higher than a majority of consent on these types of transactions. And then complex capital structures. you often find private distressed sellers who have, for one reason or another, either for asset protection purposes or for estate planning purposes, have set up a really complicated web of various companies and trusts to hold various assets. And sometimes that can be to your advantage, but oftentimes it'll simply make the approval and the closing process messy. Assets can be dispersed across a number of companies. You have to be very careful with getting approval and consent. And complex capital structures are ripe for fraudulent transfers because a unscrupulous seller can use them to play shell games with creditors. And as a buyer, even in an asset purchase, you can wind up holding the bag in that context. So now I'm going to talk a bit about some finish up general considerations on distressed purchases. One of the big areas of impact on the third party can have on a sale is the quality of the intermediary or advisor. And you get, just like with types of distressed sellers, you get types of advisors that can create, or no advisor that can create some liability and risk in the transaction or improve your chances for diminished risk. So the first is what many of you have probably seen before, which is the clueless seller, the guy who's run his business for 30 years, has never participated in a deal before, and gets informal and anecdotal advice or Google search type advice on what his business should be worth. He reads somewhere that on an article that it should be 3.5 times earnings, and he fixates on that. And having a seller without an advisor can be a real challenge at times in terms of discussing valuation. And then to make matters worse, often these sellers have attorneys who are usually a general practitioner or somebody practicing at a smaller level that's unfamiliar with transactions, and you have to educate them along the way as to why you need the particular structures that you're asking for in the purchase agreement. One of the biggest areas of risk and most frequent that I see, especially for the denial seller, is the friend of a friend type broker, somebody who's made an introduction that's going to lead possibly to a deal. There's been an email exchange where they talked about, oh, you know, you'll take care of me when this closes, right? You'll give me a little something, right? And someone goes, sure, of course we will. And then after you close, you get hit with a lawsuit where the friend of the seller asks where his 5% cut of the deal is and sues both parties. Next is the cookie cutter broker, the person who probably doesn't know a lot about the seller, who did a quick initial and superficial analysis of the seller's business, really just only has the basic information, uses a canned approach to valuation, and probably to get the deal gave unrealistic expectations to the seller. You know, you should definitely get X amount for this business based on this canned approach that I've got over here. That is really one of the biggest problems because it creates this real disparity between the expectations of the seller and the buyer when they start negotiating the letter of intent. And a lot of deals break down because of it. Finally, you have the valued advisor, which can actually help diminish risk and make a deal proceed quickly. This is my plug for exit advisors here because I consider them one of these valued advisors. They've invested time in preparing the seller for the sale. They're knowledgeable about the seller, the history of the business, what the potential risks are. They know the market segment, they know the industry, and they help the buyer by helping them quantify risks in terms of real dollar value so that the buyer can make an informed choice about where they pick their battles on the reps and warranties and the indemnities in the purchase agreement. So you've done your initial snapshot of the seller, and you assemble those various factors, those characteristics of the seller, starting with their industry, the type of distress they're in, what type of seller they are, and the level of advisor they have. And you put those things into a mix into the second box here, and that informs what type of approach you take to the letter of intent, what types of things you ask for, what types of things you start preparing the seller to accept as part of the ultimate deal terms. And they're also going to color or inform what your priorities might be, or the level and extent of your due diligence to diminish your risk. And those two things combined form the basis of the purchase agreement, which is your chief form of protection on the post-closing side for those legal liabilities that I mentioned earlier. So part two, teeing up the transaction structure. Just checking the time here. So teeing up the transaction structure, there are a number of things that you're going to need to do to introduce early on to a distressed seller to prepare them for the type of deal terms and the structure they're going to see in the letter of intent and the purchase agreement. The first of which is that the buyer controls the drafting of the purchase agreement. You see a lot of, there's no requirement that the buyer draft the purchase agreement, but it is customary, and it does afford a distinct advantage, which is why you'll see some sellers try and tilt the scales a bit by drafting their own form of agreement. And my response to that is typically to disregard that document and draft a purchase agreement, in any case, ignoring the seller's document. Principally because they typically are bare bones and have such a high risk profile in terms of what they lack that they don't justify the cost. So once you've established that you're going to control the drafting of the purchase agreement, you want to introduce concepts like the holdback, escrows and indemnities, earnouts, and the notion of a transition. And many of you are already familiar with all these concepts. So the holdback is simply part of the purchase price that you're holding back to account for post-closing liability. The escrow is another form of holdback, essentially, but is being placed with a third party, often with specific terms and metrics for its release. And the escrow and the holdback are tied to an indemnity provision where the seller agrees to indemnify the buyer for that pre-closing liability that pops up post-closing, initially from the holdback, the escrow, or if there's not a cap in the agreement, if the liability exceeds those amounts, then there's an indemnity provision forcing them to pay for it themselves. Although, as I'll point out in a minute, that's typically not a good strategy in this distressed seller situation. The earnout is, as most of you know, is simply a form of contingent purchase price, where the seller effectively earns part of his purchase price based upon the performance of the business post-closing. And that typically is associated with service businesses, especially where there's, excuse me, there are a number of key contracts for a service company, and the seller is making representations about their expected performance. You can gauge part of the purchase price for the consideration to be paid as a percentage of the revenue, for example, from those contracts post-closing. One of the things you want to ask for is a concurrent sign and close. Simple reason for that is there's a lot of mischief that can occur between signing a purchase agreement and waiting for the due diligence to be verified and then closing. Typically, a concurrent sign close allows the buyer to monitor all the way up to the date of closing. Not that you can't do it with a sign and then close, but there are some other legal reasons why you would want a concurrent sign and close date that have to do with the seller incurring liabilities. One of the big questions you want to ask as part of your deal terms is the seller taking a buyer equity as purchase price. That plays into both fraudulent transfers as well as successor liability. And then before you start this process, you really want to understand what the likely reps and warranties are. You, as the leader of the buyer deal team, you want to understand what all those reps are and what they entail, so you can discuss them actively and allocate and try and quantify to the best of your ability the dollar value risk associated with the likely outcomes of post-closing liability. That'll inform how you tweak your reps and warranties to make them stronger or lighter, and also decide who makes those reps and warranties to the buyer, especially if you have multiple owners and managers. So let's talk about due diligence. Everyone generally knows what due diligence is. It's reviewing information about the seller before you agree to terms or before you close a deal. Generically speaking, lawyers spend a lot of time reviewing documents associated with a prospective seller. I prefer a more active approach, and granted, there's usually a time constraint on a sale of a distressed company, but I can't emphasize enough the importance to the buyer of conducting interviews with as many people as possible. Because of the post-closing liability associated with buying this type of business, the liabilities can easily exceed the asset value on the purchase. And so you want to conduct in-person interviews with vendors, customers, employees, former employees if possible. I would argue the more resistance to that the seller demonstrates in terms of allowing you to interview people, the more likely there is a post-closing liability waiting for the unwary buyer. You also want to know if you're dealing with a distressed owner and or distressed business situation, because a lot of these post-closing liability scenarios arise not just out of the business, but out of the owner's conduct pre-closing, that can create real headaches and serious liabilities for the company, especially when they're perceived as an agent acting on the company's behalf. And then I skipped it, but up at the top, lien litigation searches and discrete asset searches are extremely important. I'm going to talk about how that works really quickly. One of the first things, if you look at this chart, and Andrew, let me know how we're doing on time. I think I have about 5 or 10 minutes.
Oh yeah, you've got plenty of time.
Okay, great. So you look at this chart, part 3, due diligence, and there are a lot of parties here, right? You've got the target owner, you have target management, maybe an affiliate, and maybe that affiliate's partially owned by a spouse or family members, and you've got all these transactions going back and forth, loan payments to the bank, transactions between customers and vendors, third-party buyers. And a lot of these things you can typically find through a public record search, or they might even be disclosed in the due diligence. Usually they're going to be disclosed, but almost always there's something in the penumbra of liabilities and parties. These blocks that I show in the outer ring here that are in gray color, they're undisclosed parties and undisclosed liabilities. So one of the things I recommend when you're assessing a distressed company is you've got 3 layers of investigation just on basic information about the target owner or owners and the target and maybe their affiliates. And that is to start with open source public background information, and you want to check all the target parties. The fewer owners there are, the more important it is for you to check them individually as well as the company. You want to develop a live-work history on the individual owner or owners. Again, depending on how many there are and how active they are in the business. Live-work history, an asset search, and dates for each owner and manager. Gary and I had a situation where there were conversations with an investor going on a potential transaction. One of the first things I did was a step 1 search that tracked this guy over the past 10, 15 years, showed a lot of hopping from place to place. That correlated with some other investigation. Turned out that it looked like maybe he was swindling or defrauding investors and hopping from one jurisdiction to another to avoid responsibility for his conduct. Step 2, look at discrete asset financial research or asset searches. That involves not only your typical lien searches, but searches associated with parties who have an interest in those assets. And that can reveal, for example, potential product liability lawsuits associated with machinery and equipment, potential unsecured debt on those assets, credit and credit card accounts that may be taken out by parties related to either the target, an affiliate, or the owner. When companies get distressed, they start taking out credit cards, and when they hit their limit, some of these sellers will go to family members or other companies and set up multiple credit card accounts, sometimes at the same time using the same entity before the credit reporting agencies get wind of it. And step 3 is what I think generically the military would call humans or human intelligence. What I mentioned before, interviews, and occasionally surveillance. We have used surveillance in a number of acquisitions to determine that, for instance, we had one seller who was staking the value of his company on 3 major contracts. Well, through our step 1 and step 2 searches, we figured out and deduced from that information that the seller went to high school with each of the primary contacts at each of the 3 customers, spent weekends in the casinos and hunting with these guys, and based on additional information, some surveillance found out that these customer contacts were not only getting these lavish hunting and casino trips, but they were getting cash kickbacks for the contracts. And we ultimately surmised that because the seller's cousin had recently set up a company, which we found out was supposed to do the same thing as the seller's company, that his plan was to sell the business to us, or sell the business to my client, take the cash, move the cash over to the other business, and then move the customer contracts from his buddies over to the new company. So the first of the 3 types of risk areas, remember we talked about fraudulent conveyance, successor liability, and fraudulent inducement, is fraudulent conveyance. And what a fraudulent conveyance is, and there's a lot of law on fraudulent conveyance, but it's governed by a statute called the Texas Uniform Fraudulent Transfers Act, which is the Texas version of a uniform statute. And what it is at its most basic is that the debtor, typically your target company, committed an actual or constructive fraudulent transfer of an asset. That means that they made a transfer of an asset or an obligation, like a note, for instance, if made with the intent to hinder, delay, or defraud any creditor of a debtor. And there's no fixed test for this. There's a list of 11 non-exclusive factors in the statute called badges of fraud that tend to indicate the existence of a fraudulent transfer, but may not be conclusive. For example, transfer of assets from the debtor to an affiliate, or what is called an insider, someone related to the debtor. If you transfer something for not reasonably equivalent value, which is loosely, if you sell something for way under a fair market value, those are various factors that could be considered to determine whether there's a fraudulent transfer. So how does that impact me as a buyer? Well, it impacts you because if the creditor pursues a claim under the Fraudulent Transfer Act, they can avoid the transfer, meaning that it's void ab initio, meaning it's void from the beginning. They can use an attachment or a provisional remedy like an injunction, or even get a judgment against the transferee. Here's an example, a quick example of a fraudulent conveyance. So you've got the buyer and the target. The buyer's in the lower right-hand side there. So the buyer's acquiring all of the target's assets for cash plus 20% equity of the buyer, and in exchange for those assets. But the cash and the buyer equity, because the buyer's shell company was just set up yesterday, is significantly less than the fair market value of the assets. The buyer thinks he's getting a great deal because this person's willing to sell this stuff for nothing. Because he hasn't conducted good due diligence, he doesn't know about the target creditor who has an unsecured claim against the assets. Transfers the cash and the equity over to the target, which is distributed to the target owner. Target owner liquidates target, gets rid of target. At the same time, part of the purchase price is paid to the target owner in the form of a very rich consulting agreement. So the outcome is on the right-hand side. You've got the target owner ends up with 20% of the buyer, plus this lucrative consulting contract, and working together with the buyer owner in the business gives that target creditor a claim against both the target owner, the buyer owner, and the buyer. And the target creditor can pursue on a number of different theories, including the notion that this transaction was effectively a merger between the buyer and the target because the combined ownership and because the assets of the two companies were effectively combined. So if you're the buyer owner and you're unaware of this, you'll be left holding the bag after you paid out a significant amount of consideration to the target seller. I'll just skip over this. This is here for your information. This is transferee liability. In other words, what can happen to you if you turn out to be a transferee, like in the previous transaction, the buyer owner of assets in a fraudulent conveyance. And I think I covered them briefly, the judgment, the responsibility for the fair market, paying back the fair market value or having a lien assessed against you for the fair market value of that asset that was fraudulently transferred. So successor liability, we talked earlier about the difference between a stock purchase and an asset purchase. And most people know that you buy stock, you're on the hook for the liability of the company that you bought the stock in. But most people think that in an asset purchase, you're free and clear of those types of issues. That's not really the case, because most of our transactions are not purely asset purchases. They're hybrids. They're a mixture between the assumption of certain liabilities and the purchase of certain assets. And in general, it's true that when you purchase assets and you're careful with your selection and assumption of liabilities, you can shield yourself from successor liability. But successor liability is an exception to the general rule against liability for pre-closing or target liabilities, and you can trip the exception through a number of different ways, like non-compliance with the bulk sales statute, which is a requirement in certain states that when you buy most of the assets of a company, you notify the creditors of that company. Violation of the Uniform Fraudulent Transfer Act. Various other transaction characteristics can be triggers that can, not definitively, but can contribute to the court's conclusion that you bear successor liability. I've listed some of them below. One of them, of course, was de facto merger, which is also a part of the analysis for a fraudulent transfer. So the best way to explain this is in an example. And one of the most common ways to incur successor liability is through what are called identity factors. And that is, simply put, how closely the company that emerges from the transaction, the new company, the buyer company, looks like the old company. So let's go back to our deal. Same deal terms as before. You've got a purchase price allocated to a consulting agreement for the target owner. You've got assets being transferred to the buyer, who pays for them this time, fair market value cash plus equity. So there's no fraudulent transfer issue there. The target distributes that buyer equity up to the target owner. And you get, as a result, this same consolidated structure after the deal is done. But because of the way the buyer purchased the business and is conducting the business after the closing, it creates a risk for successor liability, meaning that the buyer, even though it bought assets, is going to be treated as if it was the target for purposes of the target's liabilities. And some of the factors that plaintiffs can use to try and impose successor liability on you post-closing are the fact that you use the same company name. You're operating at the same location. You have the same suppliers, the same vendors, the same employees and managers. You have identity of ownership, meaning you have common ownership. That's a very loose element. Sometimes, some states want to see closer to the same ownership, but in others, they'll use it as a factor. For example, that target owner has 20% now, and he had 100% before. He's still an owner in both entities, so they'll tilt that in favor of liability. Or the fact that this is effectively a merger of the two companies, and buyer as an entity is effectively absorbing the liabilities of target in a merger situation. If for no other reason, you want to be careful about this, because in many cases it creates a lot of mistaken claimants because you're using the old company's name at the old location. State taxing authorities will come after you for ad valorem taxes on inventory that belong to the target. Old customers will come at you for product liability claims associated with products made by the target. You will spend a lot of time, energy, and legal fees in defending against claims that arise out of nothing more than confusion. So quickly finish up fraudulent inducement, and because I know we're running short on time. Fraudulent inducement is one of the more common but more general claims for on the post-closing side of buying a distressed company. Fraudulent inducement is really just fraud. It's nothing more than making a false or misleading misrepresentation or some omission, information that you hold back that leads the buyer to a mistaken conclusion. And one of the most difficult things about fraudulent inducement is you can start out with great reps and warranties, but their application has to be even and thorough. And what I mean by that is the more parties you have on the seller side in a transaction, the more difficult it is to trigger a breach of a rep and warranty, because you have to make sure that responsibility is spread around. So you have multiple sellers, some of whom might participate in the management of the business, others who may not. You might, same thing for owners. You might have officers, some of whom are owners, some of whom are not. You could have, in the complex capital structure scenario that I mentioned at the beginning, you could have multiple entities and they could have overlapping administrative services or management agreements that put the responsibility for their management with other companies, especially in an affiliated group. So it gets confusing as to who to pin the liability for breaches of reps and warranties can be in these situations. And you have to be aggressive and imposing as the buyer. Your first line of defense should be that each of those parties should sign on as a party for purposes of making reps and warranties. So they're all individually responsible for a breach. A secondary approach is to make some of those parties who are less potentially culpable guarantors for breaches of those remedies. The problem in any fraudulent inducement case, any fraud case on a distressed business sale, however, is that how realistic is it that you're going to be able to get a judgment and satisfy a judgment against the seller after the closing? And that goes back to what I was saying at the beginning of the presentation. You have all of these types of reps and warranties about, the company's well organized, the financial statements are true, we have title to all of our assets. Let's say you find out that one of those things is a lie post-closing, and you've got a distressed seller and a distressed owner who took all of this sale proceeds and they were gone. They had to pay off crushing debt. You have nothing to exact a judgment on. That person, that party, that entity, they're judgment proof now. So you have to think about the long-term potential, and your attorney can't just draft these reps and warranties in a vacuum, which is why perhaps oftentimes, instead of on these types of reps and warranties, not to say that you shouldn't try and get them all the time, your money might be better spent on the due diligence side, doing a very thorough, what might seem like an overly exhaustive search on the due diligence side relative to the sellers and the owners, to assess what types of deal terms you get. And because you've introduced those other provisions like the holdback, the escrow, the notion of the indemnity from the escrow or the holdback or both early on, you can push those deal terms as the true mechanism for protecting yourself, rather than reps and warranty, relying solely on reps and warranties, for which you'll have to sue and may never collect at the end of the transaction. Okay, I've got us at 44 minutes. Hopefully I didn't go too long. I've got there's a brief blurb on me at the end, as well as my email address, my bio on our website, as well as my LinkedIn profile. I've got a much longer version of this presentation, as well as a great outline on this. So if you have additional questions or issues or thoughts come up later on, feel free to contact me. And now I'll turn it back to Andrew. I think we have time for Q&A.
Yeah, let's go through a few questions. Folks, if you have them, there's a hand raising tool. You'll see it looks like a little hand. Just use that and I'll open your mic. And we had some questions submitted beforehand, so I'm going to kind of go through these. Aaron, real quick, can you go back over the total market size, kind of the calculation you had for that?
Yeah, so I'm relying on anecdotal information.
Right.
And I have seen different numbers. For as late as 2018, I've seen numbers for the lower middle market as many as 355,000 companies that fit that $5 to $100 million annual revenue number. I've seen other figures that are less than that, closer to the 200,000 business number. Again, I think people are working off different primary sources. The Small Business Administration has their own measure, which is significantly lower than that. I think it's beneath 100,000 companies that meet their definition. But I think what it will be most interesting is I'm watching analyst reports come out of New York, is their estimated, they have analytics that they run on various market segments. And there's going to be, there've been a lot of sub $5 million companies that have gone under. And that's what you read about in the news right now. A lot of those sub 5 million companies going into bankruptcy. But the reports I'm reading is that we're going to get a huge bubble of distressed company sales after, and we're already starting to see the leading edge of it, after, for example, PPP funds run out, after emergency SBA loans run out, and after their reserves run out. We'll see a slow boil that'll crescendo probably sometime later this year, early next year, with a ton of different consolidation opportunities opening up as these businesses start to hit, their threshold for, we've had enough, we've got to sell.
Awesome, thanks. And then it looks like, so Dan had a question, which I think I can also touch on. Could you provide, or do you have a list of questions that you could send offline that are kind of like a first round interview with a seller for a buyer?
Yeah, I think it's very specific. I mean, I would treat it sort of like a job interview. You want to hear their story, and you want to hear what they emphasize as part of that story. How well they know their own numbers, how well they know their own performance, and what they know in terms of the sales process and their familiarity with it, and their thoughts on other sales of competitors. Treat it like a job interview, but you want to ask that sort of background information, get the history on them, and get their fence post, if you will, for familiarity with each of the deal terms. I think if you go back up to the top, sorry, you want to measure how much time, for example, they've invested in preparing to get their business ready for sale, their motivations for doing it, and trying to identify whether they're prepared for the process. If they're not prepared for the process, it may be too soon. You may need to circle back after they've had time to do that. Although it may be worth it to you if you think the opportunity is good enough to dive back in and do some of that due diligence for them. I've had sellers before who basically said, come on into our office and you have the key to the file cabinets. So there's an art to it rather than a science.
Yeah, and Dan, I would say too, this is one of the first things that we kick off at Exit Advisors when we work with a seller. We have a questionnaire and a whole kind of due diligence process checklist that is very intense. I mean, it's down to a very, very granular level, but we also have some very high level topics around operations, revenue, customer base, that sort of thing. So I got your email. I can kind of share that from our perspective, because it's essentially going to be the same questions that a buyer is bringing to the table. We do our pre-due diligence the same way that when a buyer comes to the table, they're going to be asking the same thing. So.
Yeah, and I would gauge their reaction to getting that list as well. That'll tell you a lot about what I was saying before about how much time they've invested in preparing for this process. Because the seller who's experiencing shock and awe by getting a due diligence questionnaire is obviously not ready for the process. They weren't expecting it. They're probably, the clueless seller that I was talking about earlier that's not experienced with the process.
That's a really good point, because so much of this ties into the transparency and the organization of the seller. So even if they do have a good answer for it, they just don't have it readily available. Kind of shows that things are messy. They don't understand their operations. So, tying back to kind of our preparation process, we built a virtual data room with all of this stuff lined up so that it's kind of an open book when buyers are getting involved. So really important, not just to have the right answer, but being able to provide it quickly and seamlessly. Kind of a complex question here, submitted anonymously. How do we limit personal liability in an LBO, which is a leveraged buyout, where we are not providing a personal guarantee? So it's like non-SBA, and the company ends up going under. And then a second piece of that question is, can creditors argue that by getting personal benefits, i.e. pulling cash from the assets to pay the seller, ends up causing them to not be protected by the company's limited liability?
So in this scenario, the buyer is asking about personal liability from creditors. Is that?
Yeah, I guess so.
Buyer personal liability in an LBO.
Yeah.
Well, the answer is that it would probably depend on a lot of factors. And when you say personal benefit to the sellers, I'm wondering if you're talking about a scenario where the sellers were paid directly by the acquiring entity rather than having the debt or the purchase price satisfied through the selling entity. Those can be one of those factors that the courts look at to assess liability or create a theory of fraudulent transfer to hold the parties liable, in which case both the seller shareholder as well as the buyer potentially could be at risk. But most of these analyses are facts and circumstances where the courts look at a number of factors and see if they add up to a personal liability scenario like the one you described. It's an interesting question. I'm willing to take it offline as well, because there's probably a lot more involved than what was in the four corners of the question.
Yeah, I agree. I think whoever submitted that, feel free to reach out to either myself or to Aaron. I will say, I think the last thing I can chime in there too, because we've dealt with this with the attorneys on the purchaser side for some deals that we look at. Essentially, if you buy the business and it goes under, and you've now paid X amount for this business. I think this partially, and I'm not the legal team here, but I think a lot of that the liability protection there ties into your reps and warranties, which Aaron covered a little bit. Going back, if something was not disclosed and there was not full transparency around, that incident, and that's what causes, the business to fail, then, the seller is liable to that. You shouldn't be. There is a period in which that would expire. That doesn't necessarily mean 5 years down the road, but I think a lot of that gets solved in the reps and warranties phase during the negotiation process between the legal teams to ensure that, you're not buying something that you're unaware of.
And buyer liability on things like a fraudulent transfer. I mean, the claims that we're talking about are non-secured debt and things that are not already exempt in bankruptcy. So we're talking about really contingent unsecured claims. And so in most cases, it would come down to the facts and circumstances and the terms of the purchase agreement and the facts surrounding how the deal was structured and who received the cash consideration.
And whether it was an asset purchase or an equity, if this was an equity sale, then theoretically, yes, you're going to be taking any existing or liabilities that could come after the fact. But yeah, great question. And if there's more you want to know, let's take that one offline. Real quick, from Carl, he was wondering about kind of geography. Is it better to have a lawyer in that vicinity where the target is, or does it not matter? Kind of around knowing local knowledge.
Well, I would say it depends on the context. I think oftentimes you're better off having an experienced attorney who has industry experience rather than a local attorney who simply is barred in that particular state. So for example, if you're in Texas and you're doing a deal in Louisiana, and it partly depends on the state, right? If you're doing a deal in Louisiana, there may be a lot of circumstances, especially when you're dealing with debt, where it might pay because the law between Louisiana and Texas can be so different, where you might need a local lien attorney to weigh in on an aspect of the deal. But in most cases, I would rather have someone who has more years of experience within the industry who can identify areas of risk in the purchase and address them in the purchase agreement than simply have someone who's got, a license in that particular state who doesn't have that industry experience. Because I think that that's a more precise way of identifying, flagging, assessing, and taking care of those risks that are going to be associated with post-closing liability.
Yeah, I agree. Experience trumps. Okay, well, we'll do one more. And again, I know we had some other questions. So if you feel like something didn't get answered or you'd like to keep prodding away, feel free to reach out to either myself or Aaron, and we'll make sure we tackle them. But last one here from Guy, and I think this falls more under an opinion, but let's see. If a seller is found to be dishonest or fraudulent during due diligence, please comment on whether one should immediately walk away from the deal or continue and more strongly protect oneself.
Well, that's not usually the lawyer's call. It's the client's call. But I've been in scenarios where we're walking away is the right answer. But in others where we're able to identify misrepresentations made by the seller, sometimes it can be to the buyer's advantage. And obviously being called out on lying or misrepresenting part of the business can be very powerful as part of the negotiation. And I've seen it in rarer cases than walking away, but I've seen it work out well where you have a single unscrupulous owner who had good employees, but we were able to convert that into more favorable deal terms with higher leverage and a more stringent set of earnouts and holdbacks on the purchase price. So sometimes walking away is the answer, but not always.
Yeah, it's a good point about using it to your advantage. I think it really is a case by case, and it has to be very, if everything checks out and it's something very specific, that's one thing if you can hash out the issues. But I'll tell you, talking about red flags and uncertainty, Al who he can't speak now, but he always uses a really good reference of perceived risk versus real risk.
Mm-hmm.
If they're lying about this, are they lying about other things? And the risk, whether it's real or not, starts to give way to uncertain or to perceived risk, where there might be perceived, oh, they're probably lying about this, or they don't actually have good relations with their customer. Again, this is an opinion. We're just kind of bouncing ideas, but I think it's really a case by case, and but definitely err on the side of caution. Cool. Well, that's all we've got for today. I know we ran a few minutes over, so thank you everyone for sticking with us. And really thank you, Aaron, for the really great presentation. We will send this out to everybody as we always do in an email. I think you get a lot of value from this. You get kind of a really good guidebook almost. His slides have a lot of detail. So a lot of value there for you that you can continue to reference. So thank you so much, Aaron. And
thanks for having me.
Yeah, absolutely.